Judge Rossen-Yoakum, can you unmute so we can hear you on the phone?
How's that?
Yes, we can hear you now. So Judge Rossen-Yoakum will be coming in through the telephone and will not have live video at this time.
All right, thank you. So we have two lawyers here. Let's find out, are we dealing with a pro se litigant in one of these appeals and a pro se in the other one, different, same pro se? And
I'm pro se, Your Honor.
you're Miss Goodman? Okay. So you're not the lawyer. I'm sorry if I accused you of being a lawyer. All right, the cases are consolidated. There's two separate appeals. We'll just handle them in order. One is Sean Goodman. That's case number 5. We'll do that first against Kimberly Goodman. Ready to go?
May it please? Yes, Your Honor.
All right, let's
May it
proceed.
please the court.
Yes, sir.
Still good morning. My name is Gus Belcher, and I represent Sean Goodman, the former husband. The appeal in 2D18-3674 arises from the second amended final judgment of dissolution of marriage in the lower court. This is not the first appearance of this case in your court. There was an appeal after the original final judgment and an opinion written by Judge Solario in, I believe it was 2017. The issue in this appeal is the amount of the monthly durational alimony that the former husband is paying. Our position is that the trial court abused its discretion by mandating a monthly alimony payment that exceeds the former wife's need. The trial court required Mr. Goodman to pay $6,500 a month, resulting in an excess to the former wife of approximately $2,000 a month greater than the amount of her net monthly need of $7,800 as testified by her expert CPA.
Let me ask you a question.
Mr. Belcher?
Yes, Judge.
Let me stop you right there, because I think what this whole thing comes down to, because the $10,000 in need was included in the original final judgment. So really, I think an actual challenge to the amount of need being $10,000, that ship has sort of sailed. And I think what this comes down to is, was that supposed to be $10,000 net or $10,000 gross? Am I correct in really saying that's sort of what this whole thing comes down to?
You are correct, Your Honor. The figure of $7,800.17 is a net figure in the second amended final judgment. Now, I think maybe there was a little bit of confusion from this court's earlier opinion. It notes that the former wife's monthly need was $10,000. That's a gross figure. But then it went on to state that $3,500 of that could be met from sources other than the former husband. That figure of $3,500 is a net figure because the trial court imputed income to the former wife and also included amounts that she could receive from some non-marital trusts that she is a beneficiary of, and that amount is $5,890 gross. So it makes sense that the $3,500 figure is a net figure. So if you take a gross sum of $10,000 monthly need of the former wife, subtract her imputed income and the income from her non-marital trusts of $5,890.62. The difference is $4,109.38 to be contributed by the former husband, not $6,500. That is the essence of this appeal.
Okay, well, I think what I'm getting hung up on is in the original final judgment and as carried through to the amended final judgment and the second amended final judgment, the trial court said the husband proposed that the wife's need for support is $10,000 per month or $120,000 per year. And that did not say $10,000 gross or $10,000 net or $10,000 net. And what I'm getting hung up on is usually when you do talk in terms of need, it's determined the amounts that matter are the net income. And so I don't see anything in the record to indicate that back in that original final judgment, when the court said the husband proposed that the wife's need for support is $10,000 per month, what supports what would support a finding that what the court meant was $10,000 per month gross? Because to me, that reads like the trial court was saying, well, we've got the wife's testimony, we've got the CPA's testimony, but here we have what the husband's saying. And so if the husband wants to, is going to say she needs $10,000 a month, I'm going with what the husband's proposing. So that's where I keep getting hung up on. And then the further question is, if that is in fact what the court said, if the court said that way back in the original final judgment and that wasn't changed, how can we revisit that now?
Well, Your Honor, I'm not sure it needs to be revisited. As I understand it, and certainly I'm not, I'm probably more wrong than I am right, but as I understand it, alimony is based on need and the ability to pay. The demonstrated need of the former wife through her CPA is a net of $7,800, $7,800 basically. You're right. The second amended final judgment doesn't say whether the 10,000 is net or gross, but it does logically follow that based on the CPA's testimony and the testimony of the former wife that she needed about $8,000 a month, that $10,000 is a gross sum. So, it's her need is less than his ability to pay. I certainly don't think the former husband was volunteering to pay her more than her need. But you are correct. The $10,000 that the former husband proposes in the second amended final judgment does not distinguish between gross or net, but I do think it's evident from the circumstances based on the former wife's net need.
Would you agree with me that if we were to construe that $10,000 as a net need, then the trial court's calculations of durational alimony were correct? Assuming, so that would be roughly what, 12,000 something gross, correct? Let's say.
Well, I would, because I would concede that, because Exhibit C to the second amended final judgment, which is on page 270 of the record in this case, that has the former husband paying $6,500 per month in alimony, leaving the former wife with a net monthly income of $9,750. So roughly in my head, that's why I do agree with you, Judge. But I certainly don't think that was what was intended based on the testimony of both the former wife and her CPA. I think the $10,000 is a gross sum.
Mr. Belcher, I didn't ask you, but did you want rebuttal time?
5 minutes, Your Honor.
All right, you've used up 10 minutes, believe it or not. So you've got another 5, and then we'll go to the rebuttal time.
All right, thank you. Apart from the amount as addressed in our briefs in this case, we are asking for the entry of a final judgment in the amount of the overpayments the former husband has made since May of 2015, and the ability to offset future alimony future alimony payments against that final judgment. But I will tell you that is, I did not find a case directly on point. The cases discussed in our briefs are factually dissimilar. They do not, they pertain to offsetting disability payments against that was being received by a former spouse against support payments that were being made. There are equitable considerations in any type of offset of that nature. I do think they are present here. The former wife has been receiving more than her need since 2015. She was aware that the former husband was appealing that, and we do think it would be appropriate, although it is not, certainly not a certainty, and we recognize that. If there are no other questions, we will rest on our briefs and wait for rebuttal.
Very good. Ms. Goodman, you have an opportunity to respond now if you'd like.
Okay, may it please the court, I'm Kim Goodman. I'm representing myself. Unfortunately, I can't afford attorneys, so here I am. Mr. Belcher was talking about the final judgment, and this court's opinion also stated that in the final judgment, the judge determined my need at $10,000 a month. However, after reviewing the final judgment several times and asking other people to look at it, could not find anywhere in there that the judge actually determined my need in that amount. He simply stated that I had a need and Mr. Goodman could afford to pay for it. So I don't know where the 10,000 came from, but I couldn't find it in the final judgment. So also he refers to the $7,817, which in their brief, they referred to that and put very partial quotes from the CPA in there. And if you look at my brief, you'll see the full quote from the CPA that talks about how within the $277,000 that the court was determining Mr. Goodman's income to be, plus $18,000 for me that the vocational evaluator put in his final report. Between those two, she took that total amount and then tried to come up with budgets for both parties to fit within that amount. So that's not really applicable. That is not the marital need. My financial affidavits when I was, during the pendency, when I was still living in the house, were over $14,000 per month. And then all of the financial affidavits after that in the marital standard were over $12,000 per month. So the marital standard is over $12,000 a month. And the reduced budgets don't really apply to a situation where they've then imputed to me $70,000, which I've been unable to earn. Obviously, having earned $5,900 the year before filing and not having worked for 13 years, it's pretty difficult to go out and try to find a job at $60,000 a year. And also having some health restrictions, which you can read about in the final judgment if you like, I'm sorry, in the testimony in the trial. So the bottom line is that the vocational evaluator and my endocrinologist, who unfortunately I couldn't call because I didn't have the funds to hire him, Mr. Goodman did, both in the end agreed that part-time work from home was the most appropriate thing for me. And the imputation of $60,000 was based only on potential job titles suggested by the vocational evaluator. And he could not produce any of those, any jobs in that amount at all that I could apply to. That's on page 168 of the trial transcript. So the husband didn't meet his burden of proof for income imputation in the amount of $60,000. Florida statutes require that, quote, identifies the amount and source of the imputed income through evidence of income from available employment for which the party is suitably qualified. And also 6130 states that income may not be imputed based on, quote, income at a level that a party has never earned in the past. So obviously that imputation didn't meet that requirement. In addition, the court was aware just before ruling in the second amended final judgment that my actual income was $13,932 and that Mr. Goodman's was $299,339 without his untaxed additional benefits like in-kind and profit sharing. And those are shown on page 1169 and 1295 of my record. So he had knowledge of those facts. He knew that my marital lifestyle need was over $12,000. Like I said, in the final judgment, I didn't find anything where he had determined that my need was $10,000 net or gross, although you could assume that he meant for it to be net, because in the final judgment, he did impute the $60,000 in earned income, plus $890.62 from the trust, and $6,500 in the alimony, which reached $12,390.62 gross, resulting in a net after the number that Mr. Belcher quoted did not take out the health insurance. So the net was actually $849.05, the same as in the second amended final judgment. And that number is not that far off from the $7,817 that Mr. Goodman wants to use. So, you know, perhaps the judge went somewhere in between the marital need and the budget amount that was based on the $277,000. And Mr. Goodman is not living within that reduced budget need either.
Well, aren't those numbers fairly consistent with the numbers, the two scenarios that your CPA ran?
She did, but those were within the $277,000. She did not know that the court was going to impute any income to me, and certainly didn't, excuse me, think that it was going to be more than the $18,000 that was in the vocational evaluator's report.
Yeah, but that doesn't go to your need. I mean, the need is how much you need every month, and then there's a determination made as to how much you can satisfy of that need and how much needs to come from former husband. So when we're talking about the need, we're not at the imputation stage yet.
I understand.
We're just talking about what you need every month to get by.
Right. Well, for that we should rely on the financial affidavits then. The CPA was only testifying to budgets to fit within the $277,000 of Mr. Goodman's income. So those were reduced budgets. Those were not marital need financial affidavits.
I thought your CPA testified that you had a need of $78.17 and former husband had the ability to pay 95, 91.
Yes, but as I said, Mr. Goodman did not include the entire testimony, which I did in my brief, where the CPA explained that those numbers were, and she probably should not have used the word, the words actual need or something like that, but she explained that that was, I'm sorry, I'm not sure where to find it. That was not the actual need. That was just to fit within the 277,000. So if I'm imputed $70,000, then that's not necessary to go with a reduced budget. It should be closer to the marital standard. And also all of Mr. Goodman's cases where they found an excessive amount of alimony, all of them were based off marital lifestyle and the spouse's claimed need, not some kind of reduced budget. And Mr. Goodman never challenged any of the expenses listed in my financial affidavits either. So the net, excuse me, of $8,945.05 after the health insurance on Exhibit D, I believe is much less than the marital need, over $12,000. And yes, it's a little bit above the reduced budget that the CPA testified to, but again, that's not a marital need. And in the statute, the very first thing that's supposed to be considered is marital need. And hopefully that's what the court did. In addition, there's an error. Mr. Goodman keeps referring to over $10,000 a year from the trust, but the trust never paid that amount. There's no evidence that the trust ever paid that amount. In the 2012 tax return, the trust paid $499. And there's 23 pages of testimony where Mr. Goodman is questioning my father about the sale of the assets of the company because the company no longer exists. Parmalee Industries cannot pay loans to all of the family trusts because it doesn't exist anymore. So it didn't pay it before I filed in the final judgment, and it is not going to pay it now. So that number is incorrect. I do understand under the statutes that any income from a trust should be included, but just like a bonus or anything else, it should be regular and continuous, and it doesn't exist at all. So, and like I said, 2012, the year before filing, it was $499. So at most it should be, and that's not per month, that's per year. So nothing should be included from the trust. And they literally questioned my father for 23 pages in the transcript about that. And there is no income from the trust. So just to talk about the cases that Mr. Goodman cited, Lynn v. Lynn, there was duplicated child support award. So the resulting amount was more than the wife's claimed marital lifestyle need and is distinguishable. And in Socorro, the wife's listed need was $17,811 in the marital lifestyle, which included $6,148 for a second home that was sold. Now, I did reduce my need, so it was $14,219 a month on page 65 of my record before the house sold, and afterwards it was $12,312 on page 157. So that was reversed to remove that extra money for the house. And the other ones he cited as well were all in the marital need. So I really don't think that the court wanted to use a reduced budget lifestyle when the family income with the $70,000 approached almost $500,000 per year. Also, Mr. Goodman cites Waldman, and I think Mr. Belcher conceded this, that the excess alimony was an increase from a previous appeal or from a previous amended judgment. And it was reversed. That amount was not set off against any support. And the alimony income was not halted. So in this case, the judgment would be about $200,000 if you agreed with them on this, which, and in addition to the child support, which was recalculated using these the imputed number and the trust income, which doesn't exist, and those two judgments, and in addition, Waldman states that you can't retroactively modify child support. So they did not change that. So the $250,000 from all of these judgments that Mr. Goodman wants would completely wipe out any financial assets that I got in the divorce that I need for retirement and all of my income for the foreseeable future. I make less than $13,000 a year. So I would have nothing to live on, and I don't get any income from the trust. So I think that would be an abuse of discretion. I don't agree that no reasonable judge would award $6,500 under the circumstances. It's less than the marital need.
All right. Anything else before we go back to Mr. Belcher?
Not if there's not any more questions.
Okay, then Mr. Belcher, you have 5 minutes rebuttal.
Thank you, Your Honor. Ms. Goodman's imputed income and income from any non-marital trusts are not an issue in this appeal.
Well,
In fact,
there's a question here. The cases were not, the record was consolidated for purpose of the appeal, but the cases were not consolidated for oral argument. It seems to me that the argument we heard included the arguments that would be raised in the second appeal. So if your rebuttal needs to be
True.
expanded, that's fine.
Oh, no problem, Your Honor. Well, I was going to continue, notwithstanding that.
Okay, I'm sorry. I jumped to conclusions.
You took away my, I'm just kidding. As to the imputed income, this court, in the prior opinion in this case, stated there was no error imputing income to Ms. Goodman. And as far as the non-marital trust income, the trial court spent some time in the second amended final judgment discussing some activities that were going on in the entities or the non-marital trusts of which Ms. Goodman is a beneficiary, as far as the sale of very valuable assets for minimal consideration, promissory notes, et cetera, and so forth. But the point is this: the trial court had a concern that there were activities going on to make it look like these non-marital trusts were not worth anything, when in fact they are worth something. And that's why the yearly income of $10,000+ is included in the amount that she can provide, and that does not need to be provided by the former husband. Again, her CPA testified that her monthly need is $7,817 net. There are no conditions in the second amended final judgment. On the face of the document, it doesn't say this is a discounted budget or this is a special budget. No, that's the testimony. And based on that, the amount of $6,500 being paid by the former husband exceeds the actual net monthly need of Ms. Goodman, and that is the abuse of discretion. Thank you.
All right, Mrs. Goodman, do you agree? You said what you wanted to say, what you would have said in the next case if we called these separately and kept you to the same limitations? You want to add anything, in other words?
Well, I would like to add, you really have to look at the full testimony of the CPA. It was for reduced budgets. And the court did not say in the original final judgment that my need was 10,000 net or gross. And it would be an abuse of discretion to reduce the alimony based on circumstances. I cannot go back in time and, file a petition for modification, as in the recent Singer case, based on actual income. So if this court went back in time and reduced my alimony and then also made me pay that back to Mr. Goodman, that would be financially devastating to me. I don't understand why the court imputed $60,000 when I had only ever made $6,500. And Mr. Goodman wrote all of that language into the final judgment. So, and the court just adopted it 6 months after the trial. Also regarding the trust, Mr. Goodman again wrote all of that language, which is completely contrary to the testimony. The court looked at the document of the sale in camera and said that he agreed that my father was telling the truth about the fact that there was no money coming from that. And the remainder assets were put into a different company, which is common on the sale of a business. And the main remainder asset that they contend has, is worth a bunch of money is the house that my parents live in. So they're suggesting that that should be sold to pay these loans to the trust, which consists not only of the ones that they've listed between me and my 3 siblings, but the company also owed $1.6 million to my parents' trust. So suggesting that my parents sell their house to pay all these trust loans is kind of ridiculous. And they also are suggesting trickery on the part of my family when they had to sell the business to pay secured creditors. And my father and myself, because I was working part-time for that company at the time, that's where the $6,500 came from, and a whole bunch of employees that I'd known since I was a child, all lost their jobs. So they didn't get rid of the assets of the company to pay creditors to help me in my divorce. The company just doesn't exist anymore and isn't going to pay any loans.
All right, well, we've kind of mixed both cases together, so I'm going to call it over. Theoretically, Mr. Belcher is entitled to another minute if there was something new said in the second appeal that he wants to address. But was there anything, Mr. Belcher, wanted to add for this last minute?
No, I don't have any more rebuttal to what.
All right, so we're done.
Judge Valianti,
Yes,
can I interject a question?
I'm sorry. Yes, I can't see you, but I can hear you.
I do want to ask a question about the retroactive alimony, because
Yes.
it seems to me that we had remanded for a determination to be made with respect to that, and that was, I know the trial court was trying its best to comply with our mandate, but it seems like that sort of fell through the cracks. Mr. Belcher, I know that you had agreed and in fact had moved at one point to remand to the trial court for a determination for at least findings and a conclusion with respect to retroactive alimony. Do you still agree that that's necessary?
Well, obviously, Judge, filed that motion, I thought that would be best. I did argue, have made the argument that it's evident on the record that the trial court did not find there to be any retroactive alimony, but I'm not going to deny that there is no finding. And yes, the trial court did intend to do that. It's not in the document. So, you know, I'll just rest on the argument in the brief, but you're absolutely right. It's not in this judgment.
All
Thank
right.
you.
Any other questions from the panel members? All right, I want to thank
No.
both sides. Safe journeys back. We're going to conclude the session. We're signing off. Bye-bye.
Thank you.